Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today we are going to talk about estate planning for unmarried couples. Before I get into that, I want to give you all of my contact information so you can reach out, ask questions. We can talk about estate planning, probate, or anything within that realm. You can find me on my website at www.amandarochala.com. You can comment down below if this platform allows you to do so, or you can follow me along on social media at Amanda Rocha Law. The reason we are going to talk about unmarried couples and estate planning today is because there are so many people in this world who aren't planning on getting married or who are waiting for whatever reason, and that doesn't mean that life waits, and that doesn't mean that you should put off estate planning indefinitely or for any real amount of time if you have a need to have it. So, in my opinion, everybody over the age of 18 needs certain documents, maybe not a complete estate plan with a trust and all of that. However, being married or single or in a relationship long term or whatever it is should not be a barrier to you getting the documents that you need to make sure that you are protected and that your property is protected. So let's talk about common things we do for couples who are in a long-term relationship who are not planning on getting married in the foreseeable future. The first thing that you need to know is just because you have a relationship, whether or not it is closer than some spouses or not, does not give you any legal right to the other person's property, and it doesn't give you any legal right to make decisions on their behalf. It doesn't matter if you've lived together. There's no such thing in California as a common law marriage. So you have to provide for that other person if that's your true intent to do so. So first, let's just talk about the person and what we do for ourselves in estate planning. We protect ourselves from a medical perspective when it comes to having an incapacity. So if I lost consciousness and or the ability to make decisions from a legal standpoint, the person that would make decisions for me would be my power of attorney or my trustee. If you don't have a trust and if you don't have powers of attorney filled out, then there's nobody legally able to do that for you in California. That doesn't, even your spouse couldn't do that legally without documents signed. Now, if you are in a relationship and you want that other person to be able to be that person for you who can make a healthcare decision on your behalf in an emergency situation or be able to contact your financial institutions to help pay for your care while you can't do that or even pay your rent or anything else like that, then you need to fill out certain documents allowing them to do that. Powers of attorney, like I said. And if you have a trust, a trustee can do certain things like that for you too when you're incapacitated. Next, your property. Unless you jointly own property together and it's certain kinds of property, that other person in your life doesn't have any right to any of your personal property. So real estate is one of those areas where you have to be married in order to fully inherit the other half of the property if you own it with another person, because joint tenancy with a right of survivorship is something we give to married couples in California for real estate, and when one of them passes away, it immediately goes to the other person's ownership. However, if you own real estate with another person who is not your spouse, it is more than likely going to be what's known as tenants in common, which means you each have your own share, and when you pass away, that portion of what you own will be passed along to your heirs at law or whoever you have in your estate plan. If you don't have an estate plan, the other person who owns it, if they are not your child or spouse or parent or sibling, depending on who's alive in your life, they aren't going to stand to get any of that real estate. As far as personal property goes, jointly owned personal property like a vehicle might be a little bit different, and they might be able to actually inherit a vehicle if it's jointly owned, or a bank account they might get 100% of. But the rest of your personal possessions are just going to be passed at law to whoever your heirs are at the time. And again, your long-term relationship person is not an heir to you, and the law does not see them as any person in your life that they would pass anything along to, regardless of how lovely they are. So it is so important that if you want to provide for this person, that you make an estate plan. You cannot have a joint trust together. Only married couples can have a joint trust. However, what I typically do when I have a couple that is not married that comes to me and looks for an estate plan, I always have everybody get their own will. And there's no such thing as a joint will anyway, but you're going to need your own will. And in that will, if you want to provide for the other person, that's where you do it. As far as the other documents I talked about, ancillary documents, you can name that person as your power of attorney. You can name that person as your agent for HIPAA stuff. All of that, you can name them there if you want to. And then if you need a trust, that person could be a beneficiary of your trust. You could make them your trustee if you want to, or I guess it would be a successor trustee if it's a revocable trust. But you have to plan for that. So we would be doing separate trusts for each of you, and separate wills, but you can still cross-reference each other and provide for each other that way. Otherwise, unless, like I said, you have jointly owned property outside of real estate, most of that is not going to pass along to that person. And I've had somebody ask me, is this a reason for me just to get married? No, I don't think so. I don't think there's a reason that an estate plan would force you to get married. You can provide for anybody that you want with an estate plan. It doesn't, if you are not wanting to get married, this shouldn't be a reason to force you to do it. You could plan for someone who isn't your spouse at any time. It's just if you don't plan for them, then they're not going to be remembered. So if you have any specific questions or any general questions, or you want to set up some estate plans, please call me. Find me on my website, www.amandarochala.com. You can even schedule an appointment on my calendar for a free 30-minute consultation directly on my website without even having to pick up the phone. I will call you when you're ready. You can find me on social media at Amanda Rocha Law and send me a message that way if you'd like. Or if you want to comment down below, I can get back to you that way. If you have any concerns at all about privacy issues between the two of you, we can do it separately as well. It's totally up to you. Thank you for listening and have a great day.